If you're a green card holder or permanent resident, you may have seen alarming headlines this week claiming that green card holders must report by March 15th or face removal from the United States. These words are terrifying. You might be asking yourself right now, is this real? Do I need to act immediately? Am I about to lose everything I've worked for? Take a breath. The internet has a way of turning routine immigration updates into panic-inducing breaking news. When it comes to your status in this country, fear spreads fast. But fear and facts are not the same thing. I'm going to walk you through exactly what this March 15th deadline really means, who it actually applies to, and most importantly, who it does not apply to. By the end of this video, you'll know with complete clarity whether this situation affects you personally or whether it's simply another exaggerated headline causing unnecessary stress. Hi, I'm your name, and my goal is to help immigrants understand complicated immigration news in clear, simple language. I'm not here to scare you or give legal advice. I'm here to break things down so you can separate truth from panic. If you have personal legal concerns, always speak with a qualified immigration attorney. What is this March 15th deadline actually about? Here's the short answer. For the vast majority of green card holders, there is no new rule, no new law, and no sudden requirement to report anywhere. Nothing has changed overnight. What's happening is that certain immigration agencies have been reminding people about rules that have existed for many years. When these reminders get picked up by news outlets or social media without full context, they quickly turn into scary, misleading headlines. There is no mass process beginning on March 15th to remove green card holders from the United States. There is no nationwide order telling permanent residents to show up at an office or submit new paperwork. What exists instead are long-standing immigration rules about maintaining permanent residence. Under U.S. immigration law, a green card is meant for people who truly live in America as their permanent home. If someone gets a green card and then spends most of their time living in another country for years, immigration authorities can question whether that person has abandoned their residency. This has always been the law. The March 15th date is connected to specific individual notices sent to a small number of people whose travel history has raised concerns. A personalized notice sent to a specific person is not the same as a rule that applies to everyone. Does this apply to you? Let me be extremely clear. If you are a green card holder living in the United States, working here, paying taxes, raising your family, going about your normal life, and you have not received any official letter from USCIS or Customs and Border Protection, then this March 15th headline does not apply to you at all. You do not need to report anywhere. You do not need to call USCIS. You do not need to schedule an appointment or submit extra documents. You can continue living your life exactly as you have been. Simply traveling outside the United States for vacations or family visits does not put you in danger. Taking a trip to see relatives for a few weeks, or even a couple of months, is completely normal and fully allowed. Going abroad for work conferences or short assignments is also normal. No letter means no problem. Who does this actually apply to? This applies to a very small group of green card holders, whose travel patterns have raised questions about whether they truly live in the United States as permanent residents. When someone spends long stretches of time outside the country, especially more than 6 months at a time, immigration authorities can ask whether that person still intends to live here permanently. For example, if a green card holder moves back to their home country, works there full-time, and only visits the U.S. once or twice a year for short trips, that creates serious concerns. In these specific situations, immigration agencies may send a formal notice asking the person to explain their absences and prove they haven't abandoned their permanent residence. Those notices include a deadline to respond. That's where dates like March 15th come from. But these are individual case deadlines, not a universal rule for everyone. Common myths debunked. Myth 1. Every green card holder must register by March 15th or risk deportation. False. There is no mass registration requirement. Myth 2. If you traveled outside the U.S. recently, you're in danger of losing your green card. False. Normal, reasonable travel has always been allowed. Myth 3. Immigration authorities are randomly selecting green card holders for removal. Not true. Actions are based on specific individual circumstances. Protecting your status is simple if you follow these basic steps. Keep your green card valid. If it's close to expiring, apply for renewal early. Plan long trips carefully. If you'll be outside the U.S. for more than 6 months, consider applying for a reentry permit before you leave. Keep records proving your life is based in America. Tax returns, lease agreements, pay stubs, utility bills, school records. Most people never need these, but having them organized helps if questions arise. Never ignore official notices. If you receive communication from any immigration agency, read it carefully, respond on time, and consult an immigration attorney if unsure. The U.S. immigration system is complicated, but it's not random or chaotic. There are clear laws, procedures, and rights that protect people. When authorities have concerns about someone's status, they don't suddenly appear at your door. Everything happens through official notices and legal processes with due process built in. Immigration is not just paperwork, it's your life, your family, your future. When you hear words like removal or deadline, it can shake you. That reaction is completely human. But remember, fear spreads much faster than facts. The March 15th deadline is not a universal requirement. There is no mass reporting rule and no new law. The only people who need to take action are those who received an official personalized notice asking them to respond by a specific date. If you haven't received such a notice, there's nothing for you to do. Normal travel doesn't put your status at risk. Living your everyday life in the United States doesn't put your status at risk. Stay informed, stay prepared, but don't let rumors steal your confidence or peace. You've come too far and worked too hard to live in fear. Keep building your life with confidence.